Welcome to Rock Center Shorts. Thank you for joining us. Our guest today is Commissioner Elad Roisman of the Securities and Exchange Commission. He was appointed and confirmed to this position in September of 2018. From December 2020 to January 2021, he was the acting chairman of the SEC. He joined the SEC from the U.S. Senate Committee on Banking, Housing, and Urban Affairs, where he served as chief counsel. Before working in the Senate, he served as counsel to SEC Commissioner Daniel Gallagher. And prior to joining the SEC, he held positions as chief counsel at NYSE Euronext and as an associate at the law firm of Milbank Tweed in New York. Thank you so much, Commissioner Roisman, for joining us today.
Thank you for having me, and thank you to the Rock Center. So before I answer any questions, I probably need to give my standard disclaimer, which is the views I expressed today are my own and do not necessarily reflect the views of the commissioner or my fellow commissioners. So thanks again for having me.
Absolutely. No, it's our pleasure. And keeping with the theme of Rock Center Shorts, we got a couple of questions we want to tee up for you around the topic of ESG. And so given the business, economic, and social climate in the US right now, as we're weathering through hopefully the end of a pandemic, corporations are being called on to step up their activity across a myriad of different areas, from climate change to income inequality to racial justice. And many of those concerns land in the ESG space. And I know that boards and their advisors are spending a lot of time and energy considering how best to handle ESG measures and, importantly, disclosures to the various stakeholders they're involved with. And so from your perspective, Commissioner, how should boards consider the ESG area and this disclosure concern given how investors are focused right now?
So let me try to tackle this question in multiple parts. Let me talk about the role of the SEC with respect to boards, with respect to disclosure, and then ESG disclosure. So first, the SEC has a very limited role in the oversight and regulation of boards of directors of public companies. And more broadly, in the realm of corporate governance, the role and duties of directors is primarily and traditionally a state law issue. But what the commission does do is we regulate the, disclosure of companies to ensure that a reasonable investor has the material information needed to make an investment and a voting decision. So why do I talk about material information? It's because that's the standard for disclosure that the commission has established and has been clarified over time by the Supreme Court. So let's now talk about ESG disclosure and the SEC. So I just noted SEC mandates the disclosure requirements for companies that issue securities. And as an SEC commissioner, I have to focus my attention on the topic through a particular lens. And that is, what role do our federal securities laws play in requiring companies to disclose ESG information? And what should a federal regulator like the SEC do in this space? Our federal securities laws aim to protect investors by ensuring that investors are adequately informed to make their investment and voting decisions. And I think everyone acknowledges at least two things when we talk about ESG disclosure, and that's the E, S, and G and ESG cover a wide range of issues. And two, under existing federal law, public companies should be disclosing material information, whether it's ESG information or not. And that some ESG information can undoubtedly be material. So for example, if a company determines that more frequent storms in a particular region significantly affect their production schedule, that's material information. Mm-hmm. If a company has been having difficulty retaining talent to the point where high turnover has resulted in increased costs, that can be material information. If a company has several findings in their audit processes related to weaknesses in internal controls, that's also likely material information. So these examples highlight potential disclosures in each of the E, S, and G categories, but the relation to E, S, and G isn't why they need to be disclosed. They need to be disclosed because they reflect material information about a company. So from a director's perspective, I'd think about what ESG matters are material for investors to understand and should be disclosed. And you can do that by engaging with management and frankly, hearing from investors.
That's great. Thank you. And I like the way you brought that back to sort of where the director can engage practically with the management team. So the next thing I wanted to ask is, as recently as this week, we've read a lot about calls for the SEC to impose more ESG disclosure requirements. So what are your thoughts on that?
So I don't see our current securities disclosure framework as an obstacle to companies providing more information relating to ESG. So the question then becomes whether the SEC needs to do more to ensure that companies are providing the information that's material to all investors. And that's something we've done throughout our history. And frankly, in the ESG space, we've done that last year with 2019 human capital disclosure. And the commission's even done climate disclosure through guidance in 2010. So we've done this continuously. But people should know I'm completely open to discussing the potential for us acting in this way. But the main questions I always have are, what should these requirements look like? And how would the SEC go about implementing them? So to the first question, as I mentioned earlier, any new disclosure requirement to me has to be based on the notion that the required information is material to the reasonable investor. It must be information that a reasonable investor needs, not necessarily any other individual or societal stakeholder needs. It must relate to an investment decision. That's a decision seeking to obtain a financial return on the money invested. And there are many very laudable environmental and societal goals that particular investors have. And I personally think it's important for citizens and lawmakers to pursue those goals. But the Commission and the Supreme Court have historically looked to financial concerns when they're determining materiality. So while I've heard many people argue for increased ESG disclosure, generally, the questions I always ask, and I've had not much consensus in I think hearing, or I haven't really heard consensus on, is what information do investors specifically need to be disclosed? Here's why it's material to all or nearly all SEC filers. And this information is not disclosed under our current regulations. Let me be clear. I don't want investors unprotected. And if they're not getting material information about their investors, that's a concern. But I do need to have a more specific idea and granularity about what may be lacking in order to consider using the Commission's authority to impose a new requirement across our public securities market. Also, it must be clear to me that the requested disclosure is intended to address a problem that the federal securities laws are designed to fix. We're here to fix information flow within the US securities markets, not, for example, to address climate change. And that's a danger I'm concerned about. Using the securities laws to try and effectuate social change, that's not my role as an SEC commissioner. That's the role of elected officials and citizens. So I'm very interested in hearing from people who have specific ideas about the disclosures that investors need right now in making their financial decisions. And if we can reach consensus about specific items of information that investors need that they are not getting relating to ESG, we reach the question of how will the SEC formulate and implement such disclosure rules and monitor compliance over time. So look, I'm really glad directors are thinking about ESG and their roles as directors, and additionally with respect to SEC filings. And I'd really encourage people to come, especially directors, to talk to us directly. And I hope to hear from them, what are you hearing from investors? And if you have concerns, especially regarding liability that are associated with additional disclosures, what are they? Directors are probably the group that we hear collectively the least from. So I really encourage people to come talk to us. Our doors, at least virtually, are open, and your perspective is incredibly important and valuable. So please take us up on that offer.
That's excellent. Commissioner, we'll wrap it up here. Thank you so much for taking the time to share your important perspective on this. And thanks to all of you for joining us today at Rock Center Shorts.
Thank you.